Okay. Welcome. Today, we'll be discussing the ins and outs of evictions in South Africa. More specifically, how the COVID-19 virus has impacted on eviction proceedings and whether any reform is required. We're very lucky to have James Roos from M&R Attorneys with us in this discussion, and he's the Director of Litigation in the firm. And if afterwards you want to get hold of James, his contact details will be in the post, and you can also message him on LinkedIn. Actually, this week, there was an article on the Go Legal website, and yeah, I like that one. They post like pretty good legal articles by people in the industry quite frequently, at least once a day. Sometimes they have 2 or 3. That one was about evicting tenants from residential properties. And it mentions a report by Statistics SA that the number of people being taken to court for outstanding rental debt is approximately 3,000 a month. So yeah, that's really not a good sign. James, just to kick off, what are the things that regulate evictions?
Hi, Josh. So nice to be here, first of all. I'm hoping to impart the wisdom that I have with regards to eviction. Maybe to go straight into it, as attorneys would know, you have 2 forms of legislation when it comes to eviction. You have the Extension of Security of Tenure Act. That deals more with properties involved in farming land and more labor rights. For present purposes, obviously, we'll be dealing more with PI, the short title, and the long title being Prevention of Illegal Eviction from and Unlawful Occupation of Land Act. So I think let's stick with PI. That's the regulatory thing within South Africa that regulates how evictions proceed within court, whether that be institution within High Court or institution within MAJ.
Okay. And James, who's the correct party to bring an eviction application? Because, yeah, like just from reading the case law, we had a really interesting one where there was a bona fide possessor, and I mean, then there's the landlord, and there's the owner, and then there's agents.
So you must always keep in mind that evictions are really based on the Raven Decatio in South African law, which in essence is ownership. So if I own something, which is obviously a different form when we speak about possession, but we'll come to that. Ownership with respect to property, whether that's movable or immovable, that's where your right stems from. So to make an example, if you are the registered owner of a property or any movable property at least, that would give you a right to proceed with an eviction against an unlawful occupier. And obviously we'll touch on what an unlawful occupier is coming now. But the basis is, like I say, the Raven Decatio. Within the PI Act, however, it's obviously inclusive of ownership, but the added benefit is a person in charge of the property. So keep in mind, we're not dealing with movable properties here, like cars and things like that. We're dealing with immovable, so we'll deal with the house. Your person in charge, interestingly enough, that just adds weight. So for instance, an individual who has a right at least to sublease. So if you rent out your property to me, and in terms of that agreement, you allow me to sublease, and if I sublease to somebody else, that would be a valid ground for me to bring an eviction against that person, for instance, if that person isn't paying me rental in terms of that sublease agreement. So a watered down form of ownership, you could say. Interestingly enough, there was a case quite a while back, I remember, where we were involved in where the sheriff, so also we'll come to this a bit later, but just in the back of your mind, keep in mind that ownership in terms of evictions can stem from me as the owner of a property trying to evict, for instance, my tenant. Alternatively, it can stem from a situation where I buy a property on auction, through public auction, for instance, and the people who are living on the property, generally being the execution debtors or the execution debtors' tenants, refuse to leave and you need to evict them. So during that process, prior to transfer taking place into the name of the execution purchaser at a sale in execution, with in essence the bank sells off the property, we try to bring a claim in the name of the sheriff to say, well, sheriff, you're the person in charge of the property because you are the one who proceeds with the sale, the conditions of sale, and ensuring that transfer in essence takes place. Unfortunately, it never went, I believe, to the FCA, but a high court said no because a sheriff is in essence the executive of the law. They don't really act as an agent or a person in control of a property. So that failed. So maybe to answer your question more directly, the people who bring evictions are either an owner in terms of PI or alternatively a person in control of the property in terms of PI as well.
Oh, and can you, in your experience, just take us through the steps that you normally go through with an eviction? You know, like, is it ex parte? What is better? Application, action?
So that's also a storm in a teacup, so to say. So with your evictions, you have either your application proceedings or your action proceedings. With a person who doesn't understand legal process, the long and short of it is application proceedings are relatively quick. Action proceedings are generally quite long. How you choose one or the other is dependent on factual disputes. So for instance, if I believe that there's going to be a factual dispute with my tenant, for instance, I would generally have to bring an action proceedings, which would potentially take longer. It doesn't mean you have to at all times. It just gives a potential defense, procedural defense at least, to, for instance, the tenant to say there's a dispute of fact here, you should have brought it on action as opposed to application, where for obvious argument, application doesn't foresee a dispute of fact. It's mainly a legal argument and the facts are common cause between the parties. For instance, I'm the owner, you are the tenant, I've canceled the agreement with you, get off of my property. Whereas the opposite with regards to actions is there's going to be a large dispute of fact. It's obviously difficult to say whether there is going to be a dispute of fact. For instance, if there was a breach of a lease agreement, one might say, well, obviously they're going to argue that there's a dispute of fact. But then different principles come into the picture when the court has to determine whether there is actually a dispute of fact, and different old principles would then apply. So again, to go back to your question, generally it's brought on application proceedings, which generally take not as long as action proceedings. The proceedings, however, to have an eviction granted, that's now a process in of itself. So maybe just to take a step back again, your high court proceedings are relatively straightforward. Your MAJ court proceedings previously were different. They generally had an eviction was able to be granted relatively quickly. That now, the rules in terms of MAJ court when it comes to at least the eviction side of things has been now reflected in the same sense as the high court proceedings. So for all intents and purposes, MAJ court and high court run the same way. The only difference now that you're going to come about with is dependent on how backlogged those court processes are. So if you're sitting in Randburg MAJ or you're sitting in Joburg High, you're probably going to wait a bit longer within Joburg High because you have a lot more people going to Joburg High as opposed, for instance, Randburg MAJ. That might be a bad example, but let's say Protea MAJ, for instance, because Randburg is quite a busy court within Johannesburg. The main thing that needs to be done with an eviction, or at least the most important thing, is your Section 4.2. Your Section 4.2 is a provision within PI, which in essence is the court authorizing a certain process or service on the unlawful occupiers. And I mention unlawful for present purposes, not to say that they should be evicted, but that's just the terminology within the PI Act. So your Section 4.2 in essence is just that. It's a Section 4.2 notice which sets out, I'm going to be attempting to evict you on this date. These are the reasons why I'm going to potentially try and evict you. And you have the right to go and try and defend the matter yourself or go and appoint legal aid, for instance. That whole process, view it as something within the bigger process. That is a process in of itself whereby you have to go to a judge and you have to go and get authorization. It's both ex parte meaning no notice to the other side, as opposed to your main eviction proceedings where there has to obviously be notice because that's where you're going to be potentially evicting the person. So your Section 4.2, like I said, is both ex parte, so you go to court. Generally, it's a rubber stamping. where they just say, cool, you can go ahead and proceed. You then have that document served, being your Section 4.2 notice, together with your court order authorizing the Section 4.2 notice. Once that's been served, you then obviously proceed to your main eviction hearing. Obviously, Lewis, we didn't touch on it, but also just keep in mind, I maybe should have mentioned it right from the beginning. Your evictions is not a one-sided affair. You have landowners or property owners, at least, who obviously feel entitled to their property. You have rates that are due. You have levies that are potentially due. You have water and electricity that an occupier is utilizing and not paying for. So you can understand the dilemma, however, between that and an individual who has no money to be able to afford rental, or the other example I made where you have an individual who's lost their house because the bank has executed on it. So you must always keep in mind that it's not as just a clear cut down the line, I'm the owner, get out of my property. It becomes a lot more complex because it's a balancing exercise between the rights of a person potentially being rendered destitute and an individual who obviously needs his property because he or she has paid for it and it's an investment. Alternatively, he or she would like to live there with he or she's family. So yeah, it's a lot more intense than just this is what it is, go and proceed. But to answer your question, is your Section 4.2 notice prior to your main hearing of the eviction.
Hey, thanks, James. And I'm curious, there's some parallels, but obviously differences. What's the difference between an eviction and spoliation?
So your eviction deals with your ownership right. Like I said right in the beginning, you're the registered owner of the property. It generally shows on your title deed. Whereas spoliation deals with possession, your possessory right. So I'll give you a quick example. The example obviously we're dealing with now with regards to ownership is I'm evicting you, get out because I am the owner. And that's a very easy thing to generally prove. We'll obviously come to the defenses now that occupiers can raise, but it's generally quite a simple thing. I'm the owner, you have what I'm the owner of, give it back to me. And courts are very willing, generally, if we're not dealing with an eviction because other things come into play, but are very willing to give that thing back to you. Obviously, they're subject to some defenses here and there, but your spoliation, which is a common law principle dealing with, I was in undisturbed possession, you in essence disturbed my possession. So we're not dealing with an ownership right. And the strange example that I can give you that I normally give to clients is, for instance, if you driving your car and you're at a traffic light, I stop the car, I throw you out of the vehicle and I jump straight into it, then I drive around the corner. For all intents and purposes, I'm a thief. I drive around the corner and I decide, let me pull over and let me get some coffee. I jump out and you see me and you come running back and you say to me, that's my car, I'm calling the police, I'm taking it back. Technically, if we're not dealing with spoliation right after you've taken possession, technically you would have to go to court, or rather I can go to court to say, give me that vehicle back, being your vehicle, because we're not dealing with ownership. And you can't go to court when we're dealing with a spoliation and say, magistrate or judge, this gentleman stole my vehicle. He had the audacity to pull over and have some coffee, give me my vehicle back. Judge or magistrate doesn't care about that. They're not dealing with ownership. They're dealing with, did James have undisturbed possession? He did, because he was driving around the block. Obviously, that's different if you threw me out as soon as I got in, but I drove around the block, I had undisturbed possession, and you took that from me. So technically, I would then get the vehicle back, but that doesn't change the fact that then you can go to court and, again, argue the Raven Decatio and say, give me back my vehicle, and you would obviously win in that example I've just given.
No, that's a great example. You know, those kind of things make it, give you a hook to remember it by. And,
Yeah.
you know, I'm just wondering, because in the sort of case law that comes my way, I've seen some really interesting defenses to eviction, and 2 or 3 have been hinged on COVID and sort of supervening impossibility. And so I was wondering, in your line, what are the main defenses you see in the eviction proceedings?
Yeah, so generally, as you just correctly said, the COVID pandemic has caused a lot of individuals to raise that claim of saying, well, it's COVID, you need to give me some leeway. Because obviously you can see, as the banks have done payment arrangements or holiday periods for repayment. So people believe that they're entitled to say, listen, you can't evict me because there's a crisis going on within the country. We'll come to the regulations and how they've affected evictions, but that's not the correct way of looking at things. To a large degree, the regulations, or rather the COVID-19 pandemic, hasn't changed how evictions operate. They changed the order that's granted at the end, but you still are technically entitled to an eviction if somebody is sitting in your property and not paying you rental. Obviously, keep in mind that there's also, like you correctly said, there's those arguments of saying, well, it's impossible. How am I supposed to pay you rental in that specific example? If I've lost my job, I've been retrenched, I can't do anything, what do you want me to do? Avoiding for the time being that balancing exercise, like we mentioned right in the beginning, not being able to pay a sum of money can never be superveningly impossible. Somebody out there can pay that amount of money. Jeff Bezos, forget the amount he's sitting on now, but a few billion dollars, he would be able to afford the rental. Impossibility or supervening impossibility requires objective impossibility, not subjective, meaning you. Objective, meaning everybody. Nobody can perform in terms of that agreement. However, that doesn't mean that a tenant doesn't have a right to raise claims and say that the lease agreement with the landowner or property owner is unconscionable, or, for instance, is an unfair practice in terms of the Rental Housing Act to try and have rental reduced, for example. And obviously you can see the dilemma there, because if you have an argument based on your lease agreement and trying to remedy or rectify terms within the lease agreement to make it more tenant friendly, you could potentially be sitting with a problem, because as an owner, an example of having a lessee, I need to cancel that agreement validly. If I do not cancel the agreement validly, meaning the lease agreement validly, that is a pure defense to an eviction proceedings, because I can say, well, you didn't cancel it correctly, whether procedurally or substantively, and therefore you can't evict me because I have a right, therefore I'm not an unlawful occupier. Technically, I'm lawful. So the Rental Housing Act does provide that, or not, it doesn't provide that defense, but it gives leeway to try and show that something within the lease agreement is unconscionable, for example, because of the COVID-19 pandemic. I haven't seen it come up yet in my experience with regards to that argument. However, the argument does obviously come around where you have an occupier blatantly just saying, it's a COVID-19 pandemic, you can't throw me out, you're not allowed to. That was correct right in the beginning, where evictions couldn't proceed, but it's not correct now because of obviously we've been reduced to level 1 the last time I checked. So things are generally back on track for quite some time now, but it does affect the end goal, which is whether an eviction will be granted or not. Or rather not that, but rather whether the time period for the eviction to happen.
And James, apart from the sort of supervening impossibility and as a defense, has COVID affected eviction proceedings in other ways?
Yeah, so you must obviously keep in mind that who bears the responsibility to house homeless? The argument is obviously that bears on the state and maybe down the line to the municipality. So as a landowner, you don't have the obligation to house unlawful occupiers. So that obligation will generally rest on the municipality. So the general argument though from municipalities is we can't do it. We don't have enough money. We don't have funding. We don't have enough land. How do you expect us to house people that are getting evicted left, right, and center? So the argument though still is that's not an obligation on me as the landowner. It's an obligation on you. You need to sort it out. So you can obviously understand with regards to COVID and all those people being fired, being retrenched, not being paid their full salary, UIF not paying out when the TERS benefits were provided, or the employer being dodgy, for instance, and deciding not to pay and keeping the TERS payments. All of those things have obviously affected whether an individual can afford rental, which obviously then impacts on eviction. So that all stems back to who sits with that obligation. And from my understanding at this point in time, that doesn't sit with the landowner. So that's not an argument to avoid an eviction.
Okay. When you're successful, what are the general orders that you can secure in eviction proceedings?
So that will obviously stem back right to the beginning with regards to magistrates court and high court. Magistrates court, you must understand the difference between the two. So magistrates court generally is a lot cheaper than high court. The major difference though between mag and high is just because an order has been granted that James, you're evicted from the property, it doesn't mean that you can't appeal that decision. So within high court, I have the right to apply for leave to appeal. It doesn't mean that the order is invalid or valid. It just means I have the right to apply for it. And then that suspends the operation of the eviction order. Obviously, there are arguments to say, well, I want to execute now within the rules which you are entitled to do, but more often than not, that probably will be unsuccessful because the overarching thing is we're dealing with a person who's potentially going to be rendered destitute. So that's high court proceedings. You need to get leave from the judge to say, yes, I think I might have been incorrect, whether factually or legally, go to a full bench of the High Court or go to the Supreme Court of Appeal. That now works differently within Mag Court, whereas it's a lot cheaper and potentially can be, an eviction can be granted a lot quicker. You have an automatic right to appeal. So if I don't need to get leave in essence. If I get evicted in Mag Court, I just file my notice of appeal and that now is suspended until such time we have it heard in High Court. Automatically, as opposed to a judge who heard the matter saying, I think I was wrong factually or legally, let's take it now to a full bench or to the Supreme Court of Appeal. The orders, though, also vary depending on what judge you're sitting with and how prone he or she is to the landowner or the unlawful occupier. So you have, for instance, I generally get orders granted with 3 months, sometimes 6. That's generally been the longest. But that, again, all depends on what judge or magistrate you have before you. Although judges are supposed to be impartial and down the line, there's obviously that subjective thing of just and equitable and all of that. And that's the major inquiry within an eviction is it just and equitable, or what is the date that's just and equitable to evict? And that's a subjective inquiry because I can say it should be next week. It's my property, I want that person out. Another one could be, no, it should be 6 months because this individual's lost their job, the employer is not paying them through TERS because they're doing something dodgy. It all really just depends on that subjective understanding of the respective judge.
And James, I saw on a lot of groups, practitioners were getting frustrated with the backlogs that happened over COVID because, you know, the courts were closed and they were sanitizing, and then they just start getting back up to speed. And then one of the staff members would test positive and they would shut down again. And, you know, there was a cascade effect. Has that affected the amount of time you have to wait? Is there still a backlog? Is it a challenge? How do you get around that?
Yeah, so to be fair, and maybe just from my experience, I do believe, so case lines is the people who aren't in legal practice, but case lines is the system which in essence makes everything digital now, as opposed to physical, going to court, filing, stamping, and doing things like that. So case line was implemented, I think, just after COVID started, or maybe just before. But the system, in my experience, has made things relatively simpler when it comes to at least legal process. It, however, in my opinion, hasn't stopped the backlog. So the backlog is still sitting. If you go to Pretoria High Court, you'll be sitting for a relatively long time, as opposed to Joburg, where we'll be sitting for some time, but it's potentially not as long. And the reason for that is you must keep in mind Pretoria has jurisdiction, meaning it has the right to hear a matter because it has overarching jurisdiction within Gauteng as opposed to Johannesburg, which is a smaller circumference as opposed to Pretoria High Court's jurisdiction. So many people go there because Pretoria has jurisdiction over everything, within Gauteng at least. So from my experience, for instance, you would be sitting with a relatively long time, and it hasn't changed at these case lines because you have 2 hearing dates. You still have your Section 4.2 hearing date, which the attorney is the one that's generally handling. The client doesn't really know anything about it. The client comes to the attorney and says, please, let's get the eviction granted. The attorney handles the Section 4.2, which is a date in of itself. Once that has been obtained, you still need to go and get your main hearing date. And obviously, if your Section 4.2 hearing is unsuccessful for whatever reason, sometimes it happens. It's unsuccessful for maybe a judge doesn't like the way the notice is set out or believes that you should inform the unlawful occupier more about their rights. That then is obviously going to impact potentially your main hearing, because your Section 4.2 needs to be served 14 days prior to your main. So if your Section 4.2 has been granted, you still need to get it from the registrar of court. It still needs to be stamped and signed. I think that turnaround time there is 7 days as a maximum. You get that, you still need to serve it by way of sheriff. So you still need to send it off to the sheriff to go and serve, and sometimes they take their own time, a few weeks if need be. And obviously, if that process is either delayed for whatever reason, that's going to affect your main. And if your main hearing is affected, you need to apply for a new date for your main. And obviously, whilst you've been doing all of that process, another 1,000 attorneys or 100 attorneys have already gotten further than you have. So now your main hearing date is going to be a few months down the line, even further. So a round estimate as to getting evictions granted, you're probably sitting at about, at the best, maybe 6-7 months, at the worst, a year and above. And obviously, this is dependent on the application proceeding, because if you go in your main application and the eviction is being heard and the judge says, no, but there's a dispute of fact here, and they are willing to refer it to trial, or you request it to be referred to trial in order to avoid a dismissal, you're sitting at a trial in about 2 years. So you can obviously understand the dilemma that at least landowners have, because you have somebody sitting in the property who isn't paying anything. And I've had instances where in Lani areas, in Sandton, in Midrand, you will have tenants, but it's not really tenants in the lease agreement sense. These are individuals who have lost their houses. So obviously there's a different dynamic that comes into play. An individual who's lost their house sometimes is obviously very distraught, very upset that they've lost it, upset with the bank, upset with the individual who's bought it, doesn't believe it's right. And then you get potential people who destroy property. I've seen instances in Santon where properties have been broken with toilets, plaster has started to be removed, and the not the occupier, but the owner of the property who bought it on auction is still sitting with those bills. He's paid for the property. In essence, he's paid the execution debtor's debt for the bank. He's now paying water. He's now paying electricity, which these individuals are using for free. He has to mend the property when he eventually, or she eventually gets it. And he or she is not getting rental for it because this person's sitting there, and you need to pay for legal fees because you're sitting with an eviction that might potentially be dragged out for a year. So you can understand the dilemma that that landowners face, especially now within South Africa with regards to eviction.
Yeah, James, I'm just thinking now, listening to these stories, because I've heard some really horrific tales from people I know that have got tenants, and these tenants actually do have the means, and they play the system, and they can string it out very long and get free rent, and the landlord gets quite exasperated because they're actually losing money, and they had a granny flat or another small property in order to pay school fees and supplement their income, and they can actually get ruined after 6 months or a year. And the guys who do know how to play the system, yeah, they can damage the properties and steal fittings. And I'm just wondering, you know, we know from historically the PI and the other legislation was put there for a very good reason, because in the past we had the other extreme of horror stories of in the farm areas of people staying there for a long time being exploited, and then once their usefulness had finished to the farm or some industry, these guys were evicted, and that was horrific and it had to be stopped. But do you think that maybe the balance needs to be reset or adjusted, or there needs to be adjustment in the rules in order not to deal with the legitimate cases, but the guys who playing the system? Is there anything that can be done?
Yeah, so maybe just to touch on that, keep in mind that PI legislation was obviously enacted for that good purpose of avoiding situations where people in essence are just thrown away, and to make it more not so humiliating for the individual being evicted, because it's a very traumatic experience. I've been to properties where an eviction is taking place and the sheriff is throwing property out, you don't get a comfortable feeling when you're dealing with that. So that doesn't change the fact, though, that PI is legislation and that's executive. So once the executive decides to amend, that's an executive decision that needs to be made. Obviously, we're not dealing with the legislature now, but the executive needs to make that policy to say, listen, the scales aren't balancing in our favor, in the sense of it's not balancing with the landowner's rights. We are lopsided and the landowner suffering and the unlawful occupier isn't. I don't think that will happen for obvious reasons. I don't think we would have a situation where we would have PI amended or a new act brought into play which says you need to disregard unlawful occupiers' rights. However, I do think that's probably an amendment that needs to be brought more in an administrative sense, either in terms of more judges being provided within courts, but obviously that's now a difficult topic because who's funding this? If the country doesn't have enough money, who's going to be paying for judges? Who's going to be paying for judges to gain experience with certain cases that they aren't aware of? How is a judge going to be able to implement the PI Act when they've never dealt with it? Because judges they are experts in law, but there's some law or aspects of law where they need experience on. So how do you remedy that situation? It's not just a quick fix. In my opinion, though, however, I do believe that the best route to take would be to hire more judges if possible in order to make the process a bit quicker. Alternatively, to potentially try and avoid the time delays with having a Section 4.2 granted, and potentially trying to get the PI Act amended where it says it can be brought in judges' chambers. So judges' chambers are a lot quicker. You have it signed in a book at the judges' chambers and the judge will have it heard. Not in open court where we're all standing there and arguing why the matter should be granted or dismissed, a lot quicker. So I would suggest that potentially be an option, but obviously you can understand that amending legislation isn't a day and night thing. It takes many, many years, and many individuals would be potentially opposed to it, where some individuals might not be or would be. Another way to potentially do it would be to do the same process that Joburg High Court did with regards to a specific court that deals with commercial matters, and have a specific court that just deals with Section 4.2 matters. Keep in mind, I wouldn't go as far as saying that let's expedite evictions, because that's still a process. The process needs to be followed correctly. And expediting things, it's avoiding then the whole purpose of PI, which is to make things not as humiliating. So it doesn't give an occupier the right to just sit on the property and do nothing, but it should be implemented through the best of what it's supposed to be, which is supposed to follow due process, make sure the individuals on the property has no right to be there, and let's move forward. That I think would be a good option to take with expediting the Section 4.2 proceedings in chambers potentially. Further alternatively, but again, this relates to a monetary constraint, having municipalities able to move quicker and being able to say, because you need to serve your eviction proceedings and your Section 4.2 notice on the municipality for that exact reason, because the municipality holds that obligation to make sure that there's emergency temporary accommodation, or that if you have no access to accommodation, you come and you are able to get access to accommodation through subsidies or the like. But obviously there's a backlog. So you're sitting with hundreds of thousands of individuals who are waiting on that backlog in order to be provided with temporary alternative accommodation or alternative accommodation at that. And now what happens in a situation where the court just says, okay, cool, go and get temporary emergency accommodation. You can't jump the queues. So that's also a very difficult and policy executive-laden decision as to how do we move the municipality to ensuring that everything goes smoothly at least. And then the question comes in, but where's all the land? What land does the municipality have? How many transfers need to go through? How much do they need to pay? And that's going to be interesting whether the amendment of expropriation of land is going to play any part, whether the municipality is going to be able to just expropriate and say, here's your reasonable compensation for your land, and I'm going to be building complexes to try and house unlawful occupiers that have been evicted in essence. But it also goes back to that same point. So even your regulations under the COVID-19 pandemic has brought into play different criteria that need to be considered. And whether that's a right thing that should have been done, I would argue that it probably isn't, because the starting basis when you're dealing with PI is different to the starting basis when you're dealing with the regulations, which deal with evictions, being the just and equitable date. And there's different policy-laden requirements under that, as opposed to the all-encompassing just and equitableness under the PI Act. So should the government have dealt with that in that way? Should they have rather amended the PI Act as opposed to promulgating regulations which do that? Is that not outside or ultra vires the right for them to do that? So all of these things, it would be easy to say, but it's very policy laden. But going back to your question, I believe it would probably be a lot simpler, although still difficult, is to have a separate court that deals with it. Alternatively, have Section 4.2s granted in chambers, which currently under the PI Act, that can't be done because it needs to be an open court. So that would require amendment, which again leads back to that same problem of amendments taking too long, and how do we deal with that?
Thank you, James. That was really informative and insightful. And I must say, if any of our viewers want to comment or share their own experiences of legal practice and evictions, whether from the side of the landlord or the tenant, please do so in the comment section of this LinkedIn post. And as we mentioned, if you want to get hold of James, his email and his phone number is here in the post. Thank you, James. I've come away with a lot.
Yeah, thanks, Lewis. So if anyone needs help, let me know. But yeah, it's a difficult question to answer. How do we balance those rights of two different people on the side of a coin? People who are potentially rich and people who are potentially poor.